Welcome back, dear students. Today we will learn the drafting of two writs. One is mandamus and second one prohibition. Before we start actually the drafting of these two writs, we should know the meaning and scope of these two writs, that is mandamus and prohibition. Dear students, the word mandamus means the order, and mandamus is a judicial remedy which is in the form of an order from a superior court to any inferior court or government or any other authority to do or not to do any specific act. So to do is positive mandamus and not to do is negative mandamus. The duties sought to be enforced by this writ must be a public duty, that is to say a duty cast by law. A private right cannot be enforced through a writ of mandamus. We have a leading case on this point, Prabhadat versus Union of India. A journalist of Hindustan Times filed a writ in the Supreme Court for restoration of violation of her right to consult under Article 19. She wanted to consult Billa and Ranga, accused persons, though they were punished with death penalty. So she wanted to consult Billa and Ranga, but the jailer was not permitting her to consult Billa and Ranga. So Supreme Court issued a mandatory directions and she was allowed to meet Billa and Ranga. The two accused persons were punished with death penalty and they requested the court to issue order of mandamus directing the jail authorities to allow her to consult Billa and Ranga, and this petition of mandamus was duly allowed by the Supreme Court. Then we have another important leading case, Vishakha versus State of Rajasthan. It was held that where vacuum persists in existing legislation, Supreme Court can lay down guidelines and norms to protect fundamental rights of women at workplaces so that they can work free from sexual harassment. This order was issued in a writ of mandamus. Thereafter, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 was passed by the Parliament following the mandatory directions issued by the Supreme Court under writ of mandamus. Now, with this background knowledge in mind, dear students, we will start the drafting of writ of mandamus. First of all, you will have to choose the name of the court where you are going to file this writ petition. You may file it in the Supreme Court or you may file it in the concerned High Court. So I have chosen the facts relating to Noida in UP. So the writ will lay in the Honorable High Court of Judicature at Allahabad, UP. Then in the bracket you will write down original civil jurisdiction. Then you will mention petition number dash dash of 2010. Why dash dash? Because you do not know the writ number. Then the name of the parties. AA, son of BB, resident of flat number 906, Designers Park, Sector 62, Noida, is our petitioner, and against whom this writ is filed versus number 1, Collector, District Gautam Buddha Nagar, and number 2, State of UP. These two are the respondent parties. Petition under Article 226 of Constitution of India for issue of writ of mandamus. Since you are filing this writ in the High Court, you will write down petition under Article 226 of Constitution of India. Now, to whom this writ is being addressed. You must be very careful that to whom you are addressing this writ. You are addressing the writ to the Honorable the Chief Justice and his companion judges of the Honorable High Court of Judicature at Allahabad. The above named petitioner begs to submit as under. Now, paragraph wise, dear students, you are supposed to draft the facts in various paragraphs, and all these paragraphs will be numbered consecutively. So, para 1. The petitioner is the owner of a plot of land numbered as 707, measuring 10 acres at village Ghasipura, sector 128, Noida district, Gautam Buddha Nagar, detailed in Annexure A to this petition. So the petitioner says that I am the owner of this land. Para 2, that on 1/1/2010, a notification under Section 4 of Land Acquisition Act 1894 was published that certain land, including the petitioner's aforesaid plot, was needed for a public purpose. All right. Third, that the petitioner filed objections to the proposed acquisition of his plot under Section 5, capital A of Land Acquisition Act. Para 4, that the objections filed by the petitioner were heard by the collector on 27 January 2010, and thereafter he submitted his report with recommendations to the state government. Para 5, that the state government accepted the report and recommendations of the collector and rejected the objections filed by the petitioner. Para 6, that on 1st April 2010, the state government of UP made a declaration under Section 6 of the Act. Para 7, that on 15th April 2010, the petitioner received a notice under Section 9 of the Act to state his claim to compensation for his plot, which was under acquisition. Fine. Para 8, that on 20th April, the petitioner filed his claim to compensation, claiming rupees 10 crore as compensation for the acquisition of his plot. But para 9, on 30th April, the collector Gautam Buddha Nagar UP gave his award determining a sum of rupees 10 lakh only as compensation for the petitioner's plot. See, dear students, the petitioner had claimed 10 crore rupees as compensation and only 10 lakh were paid to him. Then next para, that the award was filed in the collector's office and notice of the same was given to the petitioner. This is the procedure prescribed under Land Acquisition Act. Then para 11, that the compensation awarded by the collector for the petitioner's plot was grossly inadequate and the petitioner did not accept it. On 10th May 2010, the petitioner made an application under Section 18 of the Act to the collector requesting that the matter be referred for determination to the district judge, District Gautam Buddha Nagar UP. Dear students, this is the procedure. If a person is not satisfied with the award, he can request the collector that his file of compensation should be sent to the district judge for determination. Para 12, that though under Section 18, the collector was bound to refer the matter of compensation to the district judge, Gautam Buddha Nagar, but he had declined to do so by passing an order dated 10th May 2010. So, collector is not following the procedure mentioned in the Land Acquisition Act of 1894. Now you are supposed to write down the grounds of your writ. First ground A. Because the order passed by the collector, respondent number 1 is illegal and void in the eyes of law. B. Second ground. Because the respondent number 1 has passed the impugned order on the basis of his whims and hence the said order is arbitrary and illegal, having no force of law. Third ground is C. Because the respondent number 1 has not applied his mind at all at the time of passing of the impugned order. Fourth ground D. because the impugned order passed by the respondent number 1 is against the principles of natural justice, inasmuch as no opportunity of hearing was provided to the petitioner. Fifth ground, E, because no reasons are mentioned in the impugned order as to why the application of the petitioner was rejected. Now the prayer. It is therefore most respectfully prayed that first prayer is that a writ, direction or order in the nature of mandamus be issued to respondent number 1, directing him to refer the matter of compensation for petitioner's plot for determination to the district judge, Gautam Buddha Nagar, UP. This is the mandatory direction which you are asking, you are praying before the Allahabad High Court. And second relief, that the impugned order dated 10th May 2010 may kindly be quashed. Because it was through this order that the collector refused to send the file of compensation to the court of district judge. And see that any other order which this honorable court thinks fit in the circumstances of the case may also be passed in the interest of justice. So dear students, this is customary to write down third relief clause in each and every writ petition. Then at the end of the petition, the petitioner has to put his signatures. You will write down the date also, date of filing the petition in the court as 1st June 2020. Then since this writ is drafted by some advocate, so you will mention through ABC advocate. He will also put his signatures and he will write down the name of the counsel for the petitioner also. So this is how, in a nutshell, dear students, we have learned the drafting of a writ of mandamus. Now moving on to the writ of prohibition. Let us understand, first of all, the meaning of prohibition. This writ prohibits the court or any other authority to which it is issued to refrain from doing something which it is about to do. जो आप काम करने जा रहे हैं उसको रोक दिया जाए. It is a kind of stay order writ. The nature of writ of prohibition is like you get a stay order from the court. So this writ prohibits the court or any other authority to which it is issued to refrain from doing something which it is about to do. And it prevents the court or any other authority from assuming or threatening to assume jurisdiction which it does not possess. If the court has no jurisdiction, then they cannot assume jurisdiction. And by writ of prohibition, they can be prohibited, they can be restrained from assuming a jurisdiction which they do not possess. And dear students, please remember that this writ is issued by a superior court to inferior court for the purposes of preventing inferior courts from usurping a jurisdiction with which it was not legally vested. In other words, to compel inferior courts to keep within limits of their jurisdiction is the purpose of writ of prohibition. And this writ lies only against judicial and quasi-judicial bodies. It does not lie against a public authority which acts purely in an executive or administrative capacity. And this writ does not lie against legislative body also. So, please remember that the scope of this writ is limited against judicial and quasi-judicial bodies. The writ of prohibition will not lie against public authority who is acting in an executive or administrative capacity. And also this writ does not lie against a legislative body. Dear students, we have this leading case on this writ of prohibition, very old case, Rural Litigation and Entitlement Kendra versus State of UP. Mining in limestone quarries in Doon Valley was causing disturbance in the environment, was stopped by writ of prohibition. Dear students, I may tell you that I belong to district Dehradun, and practicing as an advocate, I drafted this writ petition which was later on decided by the Supreme Court. although I could not appear before the Supreme Court because at that time I had joined UP Judicial Services, but I was involved in the drafting of this writ of mandamus, and finally this writ was allowed by the Supreme Court, and extraction of limestone from the mountains of Dehradun Valley was prohibited by the express prohibition order passed by the Supreme Court. Dear students, at this stage, you must know the distinction between prohibition and certiorari writs. You see, when a case is pending before the court, it can apply both prohibition and certiorari writs. Prohibition is to prevent the court to proceed further with the case, and certiorari is for quashing what has already been decided. Thus, the object of prohibition is prevention rather than cure, while certiorari is used as a cure. So this is the distinction between two kinds of writs. Now, with this background knowledge in the mind, we will start drafting of writ of prohibition. You see, you cannot draft a writ unless you have the knowledge and knowledge of the provisions and the ingredients of that particular writ, meaning of that writ, and what is the scope of that writ. Anyway, we start drafting a writ of prohibition. First of all, you will have to select the name of the court, and since the facts relate to District Gautam Buddha Nagar, Noida, so Noida is a part of UP, and the High Court of UP is located at Allahabad. So name of the court is in the Honorable High Court of Judicature at Allahabad, UP. In the bracket, you will write down original civil jurisdiction. This original civil jurisdiction, because you are not going in appeal. For the first time, you are going to file your writ of prohibition before the High Court. Then you will draft writ petition number dash dash of 2020. Why dash dash? Because you do not know the writ number. At the time of drafting, you are sitting in your corporate office and you are drafting a writ petition. So you do not know the writ number. Writ number will be given to you by the staff of the court, or if it is a case of e-filing, then computer generated petition number will be given to you later on. But at the time of drafting, you will have to leave it blank as writ petition number dash dash of 2020. Then name of the parties. First of all, the name of the petitioner: A, son of B, resident of flat number 906 Designers Park, Sector 62 Noida, District Gautam Buddha Nagar, UP is our petitioner. Versus number 1, State of UP, number 2, Inspector General of Police, UP, number 3, Inspector of Police, Noida, Gautam Buddha Nagar. These are the 3 respondents in this case. Now let us see what are the facts of this case. First of all, you will write down in your center heading that petition under Article 226 of the Constitution for the issue of writ of prohibition. Why you have 226? Because you are moving before the High Court. Had you been moving before the Supreme Court, तब यहाँ लिखते आप petition under Article 32. Anyway, now to whom you are addressing this writ petition? To the Honorable the Chief Justice and his companion judges of the Honorable High Court. Why you are referring this writ to Honorable the Chief Justice and all his companion judges of the Honorable High Court? Because you do not know before which judge your petition will be listed for hearing. So you are addressing the entire court. You are addressing the full court from Chief Justice down to all companion judges of the Honorable High Court. Next para you will draft it like this: dear students, the above named petitioner begs to submit as under. Now let us see the facts. Paragraph wise. Para number 1. That the petitioner was appointed as Sub-Inspector of Police in State of UP on 1/1/2020. Fine. Para 2. That he served the state in various capacities in the district Meerut and Noida. All right, fair enough. Para 3, that while he was stationed at Noida and serving as sub-inspector, he was served with a charge sheet dated 2nd Feb 2020. A copy of the charge sheet is filed here. Para 4, that the inquiry into said charges was made by respondent number 3 from 15th Feb 2020, who submitted a report dated 28th Feb 2020 to respondent number 2, finding the charges mentioned in the charge sheet above mentioned to be proved. Para 5, that according to rules framed under UP Police Act regulating the procedure of disciplinary proceedings, the charges above mentioned could not be inquired into except by an officer of the rank of Superintendent of Police of the division or with the approval of respondent number 2, IG of Police of the division in the state of UP. So first attack point is that the person who is conducting the inquiry is not authorized to conduct the inquiry. Para 6, that on 3rd March 2020, the petitioner received a notice from respondent number 2 to show cause why he should not be dismissed from his services. Now, the petitioner is worried. Para 7, that the aforesaid inquiry was illegal and ultra vires. Respondent number 2 had no jurisdiction to take into consideration the said inquiry or pass any order on the basis thereof. The so-called inquiry was held by a person not duly authorized to do so. So this is another point of attack, that the person who was conducting the inquiry was not duly authorized, because according to rules only officer minimum rank SP can conduct this inquiry. Superintendent of Police can conduct this inquiry. And para 8, the holding of a departmental inquiry by a Superintendent of Police is a condition precedent, a fact which must exist before respondent number 2 can assume jurisdiction or authority for the purposes of passing the final order of dismissal against the petitioner. You want that this officer should be restrained. He should be prohibited from conducting this inquiry because he is not authorized. Now you will mention the grounds of petition. First ground is because the order passed by the respondent number 2 IG Police UP is illegal, in as much as the same is not in accordance with law. Second ground B, because the order passed by the respondent number 2 is opposed to natural justice, in as much as no opportunity of hearing was ever given to the petition. Third ground C, because no preliminary inquiry was ever conducted in this matter as required by the rules. Dear students, the rules require that if you want to conduct an inquiry against a public servant, then first of all a fact-finding preliminary inquiry is to be conducted. And once in preliminary inquiry the facts are prima facie sustainable, they appear to be serious, then final inquiry may be ordered. Then fourth ground of attack is D, because no copy of charge sheet was ever supplied to the petitioner. Copy of the charge sheet is to be supplied always to the person against whom the inquiry is being contemplated. This is the fourth ground of writ petition. Fifth ground is because none of the documents which are used against the petitioner were ever supplied to the petitioner. None of the copies of the document, it should be none of the copies. So none of the copies of the documents which are used against the petitioner were ever supplied to the petitioner is my fifth ground. And sixth ground is that no copies of the statements recorded against the petitioner were ever supplied to the petitioner. This is the rule. This is the rule of audio alter partem also. You hear the other party and give him the copies of the statement also. Then next ground is G. Because the respondent number 2 is not legally authorized to conduct the proceedings against the petitioner. Next ground is because the respondent number 3, Inspector of Police Noida, was not authorized to conduct an inquiry against the petitioner. This is my another ground of attack. Then comes, dear students, the prayer. It is therefore most respectfully prayed that first prayer is that a writ, direction or order in the nature of prohibition be issued to the respondents, prohibiting them from proceeding further with the disciplinary inquiry proceedings on the basis of inquiry report of respondent number 3. Be relief any other order which this honorable court thinks fit in the circumstances of the case may also be passed in the interest of justice. You will write down the date of petition, say 7th March 2020. At the end of the petition, petitioner will have to put his signatures, and since this writ is being drafted by an advocate and writ is to be filed in the court through some counsel, so signature of counsel are also required, and you are supposed to write down through counsel ABC advocate, because the advocate has drafted this petition. So the signature of the advocate who has drafted this petition are also required to be made on this petition. So dear students, this is how today we have learned the drafting of 2 writs, one relating to mandamus and second relating to prohibition.